That's great, but what I realize is there's virtually no faculty here, which is who it's really for, I think. So, yeah, bring them up, and I'll say, you could give it to your faculty members, and, okay, thank you.
For the PowerPoint, I think that this will help control. I don't know if you also have a PowerPoint.
I do, and he put it up. I'm hoping this is going to work, but, if not,
It should work.
The public humiliation factor for not knowing technology is way low when you're my age. So,
So basically this will move this size forward. So
Okay.
I think, yeah.
all right, well, hopefully it'll work. We'll see. Thanks. I've started to use technology in my classroom, and what I do is I involve them in the process.
I never use it.
I didn't until I taught in China.
Yeah?
And it made such a huge difference.
Yeah, I guess that would
there.
be true.
But I try to do it where it's much more, and what the students have said, interestingly enough, is like, I'll put the hypos on, I don't put answers on.
Yeah.
And what they say is, and I give them the PowerPoints to take notes on, but then they can listen to the answers, and they don't have to spend all their time trying to write down the hypo.
Yeah. No, that's actually a good point.
So, I don't know.
So I think we're going to go ahead and get started, although there might be some late people coming in. But I wanted to thank everyone for coming and to thank our panelists and our moderator. Just going to give a brief introduction of everyone before we get started. So Professor Coleman will again be moderating the panel. I promised him that I would keep his introduction brief, so I'll only mention a very small portion of all of his many professional and academic achievements and experiences. Professor Coleman has been a full-time member of the faculty at Duke since 1996. He teaches criminal law and wrongful convictions, among other courses. Prior to joining Duke Law, Professor Coleman had a range of both private practice and government experiences. They include working as general counsel for the Legal Services Corporation and as a deputy general counsel for the U.S. Department of Education. He has also been the chair of the American Bar Association section of Individual Rights and Responsibilities and of the American Bar Association Death Penalty Moratorium Implementation Project. He's an active member of the American Bar Association. Our first panelist is Professor John Garvey, who's a professor at the Franklin Pierce Law Center and the author of the article, Making Law Students Client Ready. Professor Garvey received his A.B. from Harvard and his J.D. from Suffolk University. He's currently the director of the Daniel Webster Scholars Honors Program, an innovative and nationally recognized program at Franklin Pierce that is dedicated to preparing students for admission to the bar, the practice of law, and to making students client ready. Professor Garvey also serves on the Carnegie Foundation's Initiative on the Future of Legal Education, a legal education initiative on the future of law school curricula organized by the Carnegie Foundation for the advancement of teaching in Stanford Law School. Prior to entering academia, Professor Garvey was a lieutenant in the United States Navy Judge Advocate General Corps, where he had a distinguished courtroom career and received both the Navy Achievement Medal and the American Bar Association Award for Professional Merit. Our second panelist is Professor Andi Curcio. Professor Curcio received her BA from Colgate University and her JD from the University of North Carolina in Chapel Hill. She is a professor at Georgia State University Law School and is the chair of the Bar Committee of the Society of American Law Teachers, an organization which is focused on legal education reform. She has served as a reporter for the Georgia Supreme Court Equality Commission when it examined how the Georgia justice system could improve its treatment of sexual violence victims. Professor Curcio's article examines alternative assessments in law school classrooms and how alternative skills can be measured and how that will benefit students and potentially affect change in the bar exam. Finally, our last panelist is Professor Irene Ayers, who currently teaches at New York University. Her areas of research include legal education, education generally, intellectual property and trademark law and First Amendment. Professor Ayers received her AB from Bryn Mawr College, her master's and ABD from Indiana University, where she also taught writing and literature courses, and her JD from the University of Cincinnati, where she was awarded the Timothy Walker Founders Scholarship. Prior to joining NYU, Professor Ayers practiced law in Cincinnati, Philadelphia, and New York. Her article is entitled "The Undertraining of Lawyers and Its Effect on the Advancement of Women and Minorities in the Legal Profession." So without any further delay, I'll turn it over to Professor Coleman.
Okay. So what we're going to do, each panelist will speak for about 10 minutes, and then we will open it up for questions on the theory that you will be particularly interested in, some of the innovations that they will discuss, and will have ideas to exchange with the panelists. Professor Ayers, I think you're going first, okay.
Thank you all for inviting me to this inaugural conference of the Duke Forum for Law and Social Change. My article got its start a few years ago. The lawyering faculty at NYU, where I teach, had a reading group then, and we were reading books by women attorneys of color. Around the same time, the Carnegie Foundation's report on legal education, called Educating Lawyers: Preparation for the Legal Profession, was being finalized, and Ann Colby, one of its authors, met with Professor Peggy Davis at NYU and the rest of the lawyering faculty there to discuss its findings. Now, in the reading group, the books we were reading by women attorneys of color had some very disheartening stories about the difficulties these attorneys faced early in their careers. They often described being excluded from mentoring and not given the kinds of challenging work assignments that would allow them to develop as attorneys. The Carnegie report, on the other hand, doesn't talk about what happens to young lawyers in law firms. Its exclusive focus is on legal education. It criticizes traditional legal education in the United States for failing to provide adequate training in practical skills and for paying insufficient attention to professional role identity and ethics. The Carnegie report advocates that we reform legal education to make it more comprehensive, that we overhaul the entire curriculum and the way we teach and the methods we use to measure learning so that doctrinal knowledge of the law is integrated with practical lawyering skills, professional identity, and ethics. It seemed to me that there was an obvious connection between the problems that the Carnegie report identifies in traditional legal education, which I call in my article the undertraining of lawyers, and the difficulties that so many women attorneys of color describe when they write about their early career experiences. What I mean by that is that the lack of comprehensive professional training in law schools makes post-law school mentoring so necessary and its absence so damaging to new legal careers. In my article, I studied the autobiographies of African American women attorneys. All existing published autobiographies that I could find, and I found 15 of them. I won't list them all for you, but I just would like to quickly mention some names. They are wonderful autobiographies, and I encourage you all to read them. There are autobiographies by civil rights activists Pauli Murray and Marian Wright Edelman, by tax attorney Gwendolyn Parker, and I recently realized that Pauli Murray and Gwendolyn Parker are both from Durham, North Carolina. Autobiographies by federal Judge Constance Baker Motley, law professors Patricia Williams and Anita Hill, Congress members Barbara Jordan and Eleanor Holmes Norton, just to name some of them. I read their autobiographies to learn how their authors experienced law school and the early years of their legal careers. And I looked at what they said through the lenses of two different fields of study, through studies of legal education like the Carnegie report, but also through studies of the career obstacles encountered by women and minority attorneys. I was concerned when I began this article that I was casting myself as some sort of spokesperson for women attorneys of color. They can certainly speak for themselves, and they do so eloquently in their autobiographies. It's my hope, though, that my article does what Professor Lonnie Guinier of Harvard has recommended, which is to use race and gender, and I quote, as a diagnostic tool, an analytical device, and an instrument of progress in evaluating and seeking reforms of higher education. By studying the narratives of women attorneys of color, we see writ large the potential career consequences of undertraining for all law students. What I found in these narratives about legal education is confirmation of the critiques of legal education in studies like the Carnegie Report, that legal education is too narrowly focused on too small a subset of the skills needed for competence as a lawyer. Related to that criticism is a criticism by women attorneys of color that law school fails to engage students in learning. For women and minorities, there are many factors contributing to disengagement in law school besides the narrowness of the curriculum and the uniformity of teaching by the case method. In my article, I highlight one particular cause of student disengagement that's related to the way law schools assess student learning. It's disengagement caused by the myth that legal ability is an innate talent that can't really be taught. Because of mandatory grade curves, and because of courses where the only feedback, if you can even call it feedback, is a single end-of-semester exam, it's easy to see how you could come to believe that myth. And for some, the rational response is to disengage. I'm sure you've heard this from 1Ls right around this time of year. They get their first semester grades, they're all Bs or they're mostly Bs, and they decide, there's nothing more that can be done to get As, which seem to have been mysteriously obtained by students who didn't work any harder than they did. And so they decide, hey, I can work a whole lot less for those same Bs. For some students, women and minorities particularly, the consequence of this myth of effortless genius is a complete disengagement from law school that just makes the curricular undertraining worse, as students mentally check out of their courses and detach themselves from the entire law school experience, not participating in internships or law student groups or activities, just kind of doing what they need to get through. When women attorneys of color write about what happens after law school, in the early years of their careers, I found that there are two basic types of stories that they tell. One type is a disillusionment or betrayal narrative about inadequate mentoring or about abusive mentoring. The paradigm, I discovered, is Anita Hill's autobiography, Speaking Truth to Power. Then there's a second type of narrative, which I call redemption narratives. These are the success stories, where the authors express overwhelming gratitude to early career mentors who voluntarily gave them the legal training they didn't get in law school. And the paradigm of that story is Constant Baker Motley's autobiography, Equal Justice Under Law. I think it's pretty easy from reading the disillusionment and betrayal narratives to understand how the shortcomings of legal education are implicated in these stories of early career difficulties. To me, the most damning stories for traditional legal education are really the success stories, these redemption narratives, because it borders on tragic that law schools leave their new graduates so ill-equipped for actual legal practice that they speak in near religious tones about their eternal gratitude to the mentors who selflessly provided them with the professional training that law school should have, but didn't. In my article, I also study the autobiographies of women attorneys of color to learn what does work. What kinds of education, what kinds of teaching or mentoring create the engaged legal learning that leads to successful legal careers? What I found really confirms many of the Carnegie Report's recommendations and suggests that the Carnegie Report should have been much more explicit about how traditional legal education disproportionately disadvantages women and minority students, and that the Carnegie Report should also have been more explicit about how the reforms that they recommend will advance the democratic missions that so many law schools proclaim for themselves. So briefly, here is what I learned about the features of successful legal learning as described in these autobiographies by women attorneys of color. First, there's a focus on improvement with frequent, regular assessments of progress. The learning theorists call these formative assessments, where improvement is rewarded with increasing challenges and more intensive feedback as progress is made. 2, there's a near egalitarian relationship between learner and teacher, marked by mutual respect and mutual learning. 3, there's collaboration between learners and between learners and teachers. These collaborative communities share common goals or common purposes. 4, there's attention to the development of legal imagination, such as having to come up with novel legal theories, novel solutions to legal problems. And finally, there are small learning groups, not necessarily small law schools, but within larger schools, there are small classes with small group learning. I think it'll be challenging to make these changes in the traditional model of legal education, but if we don't, I think we should be clear about the consequences. By failing to provide comprehensive professional training, using methods calculated to engage law students, law schools will continue to fail to live up to their own democratic missions. Instead, will set up students, especially women and minority students, for tremendous difficulties in their early careers. So thank you, and I will welcome your questions and comments after everyone on the panel has had a chance to speak.
Thank you.
And now, the real challenge. Can you make the technology work? Okay, the tech guy, I have to tell you what I tell my own students is my parents had us to help with chores. I have my children to help with technology. And now how do I turn this onto that? The guy behind the screen did it. Okay, thank you very much, Andi Curcio. And I think this conference and the work y'all doing is great. And the purpose of the conference is about how can we create educational equality, right? And Irene opened this session by talking about the fact that how undertraining law students has a negative impact on our women students and our students of color. What I want to do is build upon that by a brief review of the problems with our current assessment systems, then suggest some concrete alternative assessments, and then talk about very briefly how we don't know if changing what we do will have a positive impact on our students, but we should know that, and that we have an obligation to actually begin devoting the same kind of scholarly scrutiny to our teaching and assessment that we put into our other scholarly pursuits. So that's the start. Oh, look, I could do that. Okay. The way that we assess, right? LSAT, law school exams, bar exams. There are numerous studies which show that each step of the way has a discriminatory effect on students. The LSAT keeps a number of students out. Law school exams have a performance gap and have a definite. I have to stand at the podium. Oh, okay. Oh, it's hard to get an Italian to actually sit still, but I will. Okay. So all of these actually studies have a documented effect of the negative impact they have on students of color. And what's the problem? You know, they all test relatively similar skills: critical analysis, critical thinking, issue ID, issue analysis, tested in very similar ways. Right? And they have similar problems, right? Which is they test a small subset of the skills you all will need to be effective lawyers. They test them in ways that are not how you're going to use them in practice, because no one is going to say to you, here's a problem, here's four multiple choice answers, choose the one that's least wrong, right? And they all also serve as a barrier to diversity in the profession, right? So then the real question is, oops, we're one up. If we do it different, will it make a difference, right? If we do change our own assessment methods as they exist, can we make you more effective lawyers? Can we increase diversity in the profession, right? And what's the benefit of trying to answer that question? There's a couple. One is, we may actually improve our teaching and your learning, right? And the other is if we show it can be done differently and kind of on the classroom model, then perhaps bar examiners will also take that and run with it and begin to have bar exams that do a much better job of measuring who will be a competent lawyer, right? So what's the process? We have to think about assessing differently, we have to implement different assessments, and then we have to study it, right? This one I skipped because I'm low on time here. So how do we think differently, right? How do we begin to do it differently? And some of this I'm going to have to ask you to take back to your, if you think this makes sense, you're going to have to take it back to your professors, right? And say, I think this makes sense. One of the things that all the educational literature says, right, is that students learn best with multiple assessments, right? You take a test, you get feedback on the test, you learn what you did right, you learn what you did wrong, next time you improve. Now, I don't know about here, but I know about where I teach, that is not the norm, right? In fact, it's as far from the norm as you get. So one way that your professors could assess differently is simply taking their end of the semester exam and giving it to you in small chunks, right? A fourth here, a fourth there, and 25%. Another way they could assess differently, if they didn't want to have to grade all that during the semester, might be to give you homework assignments, right? Here's a short essay question, write it, and then in class you get an annotated rubric, we'll go over it, and you can self-assess and see what you're doing wrong. And for those professors really into technology, what they could simply do is clicker quizzes, right? Put quizzes up on the screen, and you can click to see if you actually know the substance, right? There's a lot of different ways to do multiple assessments. One of the other things, and this is really, there are numerous wonderful studies about the skills you all will need to be effective lawyers, right? And I am not saying, by the way, that you don't need critical thinking or that you don't need to be able to issue spot and do analytical reasoning. That is absolutely critical to being a good lawyer. But it's just not the only thing. You need to know how to do fact gathering and investigation. You need to know how to talk to a client. You need to know how to listen to a client. You need to know how to negotiate. One of the skills that's very important is the ability to see the world through the eyes of others, right? You need to be able to figure out, ooh, this is an ethical problem. What do I do about it, right? There's a whole host of skills that you need, only a few of which are in addition to the ones that you're taught. So, one caveat, and I say bring this back as well, is that before we talk about assessing additional skills, we should not test what we do not teach, right? So you have to bring that back too. But assuming that your professors want to go and do something different, and even if they don't, I'm going to suggest that all of you begin to think like this because it will make you better lawyers, right? One kind of slight twist on today's classroom would be simply to start looking at problems through a different lens, through a fact-gathering lens, right? You might get a problem and say, what facts does the judge need to answer this question? What facts would I need to ask my client in order to answer that question? Where would I find those facts, right? Because in the real world, you don't get a very neatly constructed problem with all the facts in it. You need to begin to think about what facts do I need and how do I find them? And you know what? If your professor gave you some practice doing that with questions and answers, it'd be completely legitimate to add a question like that to your exam, right? And it would be testing another skill. Another thing you can do, and professors can do this very easily, is actually make you do some fact gathering, right? They could give you an assignment outside of class that required a little independent research, right? In a Civ Pro class, they could give you a problem where you had to find out, you had to know
if subject matter jurisdiction existed. So you'd have to do some internet research to find out where a corporation was incorporated and where its principal place of business was in order to answer a question. In a property or real estate transaction class, you might actually have to go find out when a deed was recorded in order to answer a question. Right? In a corporations class, you might actually have to go look up on the internet the different documents in the Secretary of State's office to answer a question. Those are the kind of things real lawyers do, and asking you to do them, even though it's extra work, really inures, I think, to your benefit. Another thing that can be incorporated into classroom assessment is document drafting exercises. There is not a class you're taking that you couldn't be asked to, well, maybe there is, but there are very few classes where you couldn't be asked to actually draft a complaint, right? Where you would have to identify who are the parties, who are the claims, what are the elements, what are the facts that you need, and put them into a document that lawyers file all the time, right? If you're in a contracts class or, a transactional class, why aren't you actually drafting contract clauses? Why aren't you editing contract clauses, right? Wouldn't that teach you the contracts concepts you need to know? And if you're doing it in class, isn't it fair to actually assess you on that, right? Deeds and easements from property, all the same kind of thing. We could do a wide-ranging skills assessment, and one of my colleagues does this. It's a great idea, right? He brings somebody in, has students interview that person, webcasts those interviews, and says to his students, you need to write a paper, and in your paper, you need to talk about what you thought the client wanted, what you thought the client's perspective was, right? How your own kind of bias and stereotypes and judgments may come into play in your assessment of what the client wants, right? And then also, let's look at the interviewing skills and the listening skills. Critique that, right? Critique, did they identify the ethical problems? Did the students suggest reasonable potential courses of action, right? You could write a paper on all of that. And finally, I know you all know this, a key to lawyering is being able to successfully work in teams, right? So there's no reason not to be giving some of these to you in teams and having you do self and peer assessment of your teamwork. Right? Okay, so then the last piece is going from assessment implementation to scholarship about assessment, right? And why scholarship? Well, a couple of reasons, right? I mean, one is obviously scholarship puts things out there so that we all as professors can learn from what other professors are doing. Two, and you can bring this back too, that all this alternative assessment takes time, right? And professors say, well, I have to do my other scholarship. Well, if you can do scholarship on this, maybe that's some of the trade-off for you, right? And finally, I'm really encouraging empirical scholarship, because empirical scholarship often tells us what we don't know. For example, in my civil procedure class a couple of years ago, I gave students 5 simple essay questions, annotated answers, rubrics, I graded, and I did this to help my low-achieving students, right? That was my goal, that's what I was going to do. And then we did an empirical study. And you know what? I did help my students, but not my low achievers. What the empirical results showed is that all that work I put in had a statistically significant impact on my students with above the median LSATs and above the median UGPAs, right? So when we do empirical work, we gain knowledge and can kind of counter some of the assumptions we might have, right? And the other thing is empirical work has a lot of persuasive power. So, what can happen when you do empirical studies? Okay, I'm going to finish. That'll be real fast. These 2 studies actually are seminal studies. One shows that you can potentially do the LSAT in a different way with a non-discriminatory impact. And one shows if you give take-home exams, you may reduce the performance gap between your students of color and your white students. And I'll switch those back up, or anybody who wants them, come see me. You guys don't really need to know what you need to know to do empirical research. And if your professors are interested in doing that, they can go ahead and read the article, suggest that they do that. You can also tell them they don't have to be a dragon slayer. They can do this in baby steps. And finally, many people say, well, you know, the system we have is the best that we can do. It may not be great, it's the best we can do. My answer is you never know what you can do till you try, and John is going to talk about what happens when you try.
You know what, John, I just messed up again. I'm going to have to get yours back up.
You clicked, didn't you click this? Was that what you clicked?
I tried to get something down here. We may need the guy behind the curtain. Okay, thanks.
Thanks. While they're doing that, let me ask a couple of questions here, get you participating on a Friday afternoon. How many of you are professors? How many of you are law students? How many of you are something other than professor or law student? All right, well, thank you all for coming. This is a lot of fun. I'm actually humbled to be asked to speak and to participate in the inaugural edition of this very important journal. I think this is a wonderful idea. I'm also very proud to be asked to speak at a school where my student application was rejected in 1974. So I only have 7 or 8 more to go, and I'll be all set. It's great. I'm looking forward to it eventually. I have time. But the background for me in legal education really came a long time ago. I was raised by a person who, for the most part, was a teacher at a teacher's college, and so I went to what was called a lab school, and this was before the federal government had requirements where they had to get consent in order to do human studies on individuals. So I was a human study, and the consequence was that we'd have these teachers that would stand behind the two-way mirrors and they'd watch what we were doing during the daytime. We got very used to being guinea pigs. So now, after 27 years of practice, I love the fact that I am involved in a petri dish of my own here, directing the Daniel Webster Scholar Honors Program. My background was as a civil litigator for many years, and in the business of practicing law and the profession of practicing law. So it was great for me when I got this opportunity after 20 years more or less of being an adjunct to get a chance to develop what was at the time, and still is to some extent, the only one of its kind in the nation, and still clearly the first of its kind program. You've already heard a lot about the Carnegie Report and the other studies that say that education reform is necessary. What I'm going to try to do in a very short period of time is give you an overview of that part of my paper which focuses on the Daniel Webster Scholar Honors Program and gives you a sense of what it is. See, now I've never used a PowerPoint, but I just want to show everybody can learn new things. It's working, great. How many tuition dollars do you think are spent per year by law students in the United States? 500 million? 1 billion? 2 billion? Raise your hand when you think I'm over. Am I over yet? Am I over? 3 billion? I'm helping you prepare for the LSAT or the multi-state here, okay? There's 4 answers. You got to pick the best one. Which is the best answer? 500, 100, or 1 billion, 2 billion, or 3 billion? What do you think? The answer is $3 billion in tuition. That's right. Law school, I know I'm saying some things that may seem impolite in a law school setting, but law school is an edu-business. It is a big, big revenue-generating endeavor. Now, why do people go to law school? To become plumbers? To become architects? To become law professors? Or to become lawyers? Why do most people, I should say, go to law school? To become lawyers. Okay, so what do most lawyers do? Write mystery novels? Become politicians? Become professors? Represent clients. What do you think? And the answer is represent clients. So we've got $3 billion a year that's going to educate law students, most of whom plan to become lawyers who represent clients. And lawyers, when they become lawyers, have a fiduciary obligation to their clients, right? So what do we as law professors and what do we as educational institutions have? Law schools are paid to prepare these future fiduciaries, and law schools have a fiduciary duty to the future fiduciaries. That's what the Daniel Webster Scholar Honors Program is all about. We must adequately prepare law students to be lawyers. And law schools can and should do much better. That's not me saying that. That's best practices. That's the McCrate report in 1992 that was put out by the ABA. Many, many thousands of hours of volunteer work looking at education and saying what is needed. That's the Carnegie report in 2007 saying the first year of law school is pretty good, but the last two, It is not preparing law students to be lawyers. And then best practices put out by CLEA, the Clinical Legal Education Association, Roy Stuckey primarily involved in that, and that's where that quote comes from. I didn't say that. Roy Stuckey did. Law schools can and should do much better. Now, how can we do our job? What have others said about the Daniel Webster Scholar Honors Program? I'm just going to, before we get to the end, I'm going to give you a few. This is educating lawyers. That's the Carnegie report. The gentleman who did the assessment piece for that book said that the Daniel Webster Scholar Honors Program fuses instruction and assessment in the most intimate and integrated way that I have ever seen. 2 years of it. It's 2 years of what we actually recommended in the Carnegie report, integrated in such a way that truly instruction and assessment are indistinguishable. And Andy's colleague, Clark Cunningham, said that it's one of the most promising innovations in legal education currently taking place in the United States. And the SALT, of which Andi is the chair of the committee that we referred to, said in the Outcome Measures Committee report, where they were describing what needs to be done further in law schools, and there's new outcomes assessment coming down the pike, they said Pierce Law, through its Daniel Webster Scholar Program, is developing and testing assessment tools for a wide range of learning skills. That program and others like it should serve as a resource for this committee. So let's real quickly talk about what that program is all about. The last 2 years of law school, you still matriculate with your class. You have 6 DWS courses, 4 electives. Those are courses that would otherwise be electives for other people, but you have to take them. You have 6 credits of clinic and or externship. You must maintain a 3.0 GPA while you're in the program, and you can't get below a B- in any DWS course. Because the Supreme Court of New Hampshire feels that this is such a useful educational process, this is a bar examination equivalency. They deem you to have passed if you create your portfolios, get them examined every semester, and you actually pass the bar exam subject to taking the multi-state responsibility exam and passing the background check. So what do scholars do? First of all, lots of simulation. They litigate an actual case. We break up into 2 law firms. They use real court reporters who take real-time depositions of standardized clients and witnesses who are trained how to play the roles. We use real judges in their real courtrooms to argue motions for summary judgment that have been put together based upon the transcripts that are created in the depositions that are taken, and the court reporters transcribe them. They have trials in the second semester using the transcripts and find out what it's like when you ask a crummy question and how hard it is to pin somebody down on it when they start trying to get them to testify. They use client interviews with standardized clients. These are people, as I said, who are trained, and they actually are trained to be assessors of these students, which I'll mention quickly later. And then they have witness interviews. They have negotiations. They mediate. They have business transactions where they write documents, all of this in the context of simulation. And then Simple is something that's coming next year. This is a simulated software program which is being used in Glasgow, Scotland right now, which we will be using to run some of these programs for an economy of scale. They also meet real clients. They work at the Legal Assistance Referral Center, taking intake on clients on the telephone and providing real assistance for needy clients. The SWAT team for the New Hampshire legal assistance provides a SWAT team for landlord and tenant issues, for things that need to be taken care of right away. They work in clinics, and they I don't know what just happened to that, but they have externships. There it is. And so they're required to participate with real clients before they get out of school. How do they learn? They get feedback from professors. This sounds like what Andi and Irene were talking about. They get feedback from peers. They grade each other as part of the learning environment. They get feedback from judges, from outside lawyers, from court reporters. The court reporters, when they're done, actually give them feedback on how they did and what they could do better. They get feedback from the standardized clients who actually assess them, from the witnesses, from the bar examiners every semester. And they get personal feedback from themselves on their journals and their reflective papers that they have to do as part of the program. How are they assessed? Again, looking to what Andi talked about. It's formative and summative. They get lots of opportunity during the semester to improve, to get feedback on how they did, and to do it again. They get a rubric of expectations before the semester begins. Here's an example of a rubric that is used in pretrial advocacy, just the first page of it, where they're shown, this is the first of the 10 McCrate skills and values. This is problem solving, skill number 1. They're shown the McCrate skill. Over here, this is the Zedek and Schultz study, which we were given permission to use, where we describe further description of what that would look like. And then over here, right down the rubric in conjunction with the syllabus, it shows the student where they're going to have the opportunity to demonstrate, to first learn and then to demonstrate that skill or value that's part of the course. It's transparent. They know how they're going to be assessed, and they get an opportunity to do it again and again. In addition, they have formative assessment during the review of courses from multiple sources. They have the portfolio assessment at the end of each semester, which the bar examiners and I as the director and the teachers look at. The portfolio interviews with bar examiners each year. So each year they go meet with the bar examiner who's reviewing their portfolio. There's one bar examiner for every 5 students currently in the program. They also get the review of the standardized clients, and this year for the first time, as a requirement of successful completion of the program, they must successfully complete a standardized client interview, and the clients who have been trained to assess them must give them a satisfactory grade in that. The result, as you've seen before, it's, according to Lloyd Bond and others, a program that is doing what we've been talking about today. We're not done yet. We're in the 3rd year of a pilot. We have a lot of work to do, but we're doing it, and we're trying, and we're encouraging others to do so. The article talks about how it can be replicated. I hope that professors will take seriously some of the ideas that are raised there on how you go about creating an opportunity like that for your students, because remember, they're the ones who are paying for everything. They're the ones, 84%, according to Bill Henderson now of Indiana, 84% of tuition dollars are paid for by the students. So they should be driving this bus. They're the ones who should be getting the education that they're paying for. They're the ones, when they get done, who should be client ready. Thank you.
Okay, we have about 15 minutes for questions, comments, discussion. So, yes.
Hi, my name is Lauren Randall, and I'm actually a JD MBA, and a lot of your ideas sound like an MBA style of learning, having assessment throughout the year, and peer work. What would be the barriers to implementing that in a law school setting?
One of the main barriers is our culture and tradition. Right? I mean, faculty are and students are very used to I'll put all my energy in at the end. Faculty are used to grading at the end. There is also some, interestingly enough, downside to faculty who are willing to put in the extra time grading as you go, which is, interestingly enough, our student evaluations go down. Because when you will get graded kind of periodically, you can no longer believe that we're really sweet and kind and would never think of giving you, So for untenured people, I think that's a barrier as well. But mostly it's tradition and culture, and not valuing as an academy really strong teaching, but instead valuing, scholarship, much of which in the time I've been in the academy has become more and more esoteric.
Yeah, I would add to that, sort of following up on what Andi is saying, that to some extent law professors do what they deliver the kind of education that they got as law students, right? This is how things, how they were taught, and so that's how they teach. And I also think there are economic reasons behind it. It's cost effective to put one law professor in front of 200 students. You can't run those kind of business school, I don't think, business school model classes in the same way. It's much more expensive.
As I say in my article, law schools generally run in the black, and also law professors historically have come up from a development that came from the 1800s with what was called the Langdellian model of education, which is the Socratic method and the case book method. And that education is cheaper because you can fill a classroom, and it's also, in my view, and I can say this after 23 years, I guess, of teaching, it's less effort on the teacher's part. That is the truth. And that may seem indelicate to say, but the fact is that as long as the AALS and the institutions put different values on different things, the teachers are in some ways duty-bound to go toward those things that are given value. And until the schools say that the top priority is educating law students, then that's the issue. But I think it's all there. Like you said, there are models that are available. It can be done. We just need to put the priority on it, and it will happen. Yes?
How many students you have in the Daniel Webster Scholarship?
At the current time, we have 15 in each class, which is about 10% of the class. We have 150 students per class in the school. So it's about 10% of the class at any given time. That we are intentionally doing while we're in this petri dish state. But the implementation of Simple, for example, this in the fall, is designed to try to find economies of scale. Paul Maharg and Karen Barton are doing really good work, along with Clark Cunningham of Georgia State, and they've already evaluated these standardized clients, for example, can be trained, and I have 8 of them, and you can run through 150 students with 8 standardized clients. That's pretty easy to do. And they're also running a pretrial advocacy course in Scotland where they have 150 people, and they're doing it with 6 TAs who are behind the scenes in the software program, playing a variety of roles that are predetermined and preloaded. I'm going over there this summer to work on uploading our first program for that in the fall.
Hi, Brooke Gurley. I agree with everything you guys said. As a second year, I start to wonder why I'm going to be here for another year just taking classes. And I'm trying to get out do an externship. But how would you react to people who say, well, you're going to learn it anyway. Every lawyer that's come up has obviously not wanted to do these things, so why put forth the effort when you have to learn it?
Go ahead. That's a lie. I mean, I'm not, that's not, you 84% of women attorneys of color leave their law firm by year 5. That's a statistic from 2005, so just a few years ago. And one reason is they're not being trained. They're not getting the rest of their education. So I'm saying we should be providing it in law school, because the model that used to work, people would say, okay, law schools aren't best positioned to give this kind of training. You get that training on the job, what you were saying, all lawyers sooner or later learn how to do these things. Not really all lawyers. Upper middle class, white, male lawyers, maybe. The system work for them. It doesn't work for everybody.
It's not even working for them anymore because of the economic cram down that's happening in the market. I saw it. I practiced as a civil litigator, and I wound up for a number of years being chair of a litigation department. When I first went to that law firm, when I got out of the Navy in 1981, they had a rotation program in that law firm where you spent your first year rotating through the various departments to be exposed. By the time I had been there for 5 years, that program didn't exist at all, and you were just on free assignment for a period of time while, while you tried to find a niche and found out which senior partners would give you work. At this point, by the time I left 3 years ago, and it's one of the larger firms in New Hampshire, and I think it follows the models to a great extent of firms around. You were expected to declare when you showed up what kind of work you were looking for and what kind of practice you intended to practice. So you came out of law school intending to know what you were doing, expected to know what you were doing, and expected to declare it, and then somehow figure out how to do it on the job.
Yeah, I'm in my last semester of law school, and what you guys said makes way too much sense. But one potential traditionalist response I feel like might be is whether or not you're trying to supplant something that I think is still valuable about like the first year experience, which is learning legal reasoning. There is something that happens, I feel like, that you learn abstract reasoning, you learn how to apply rules and how rules interact analytically. I was wondering if you think that the suggestions you're making are intended to supplant that experience, or is there some sort of balance that you're trying to achieve?
Can I answer that? I think there is a fundamental false dichotomy in law schools, promulgated mostly by law professors, that there is substance and skills. There is no way you can do the skills well if you don't know the substance. They are actually tied, they are not separate. And I think that it's a mistake. I mean, I think legal reasoning, critical thinking, knowing how to read a case, knowing how to figure out what's a holding, knowing how to do synthesis are critical skills. But they're certainly not all the skills you need, and you're also needing to, unless you're going to be solely an appellate lawyer, right? You're not getting to use those skills in the same ways as you would use them in practice.
Yeah.
I wanted to actually build off what you just said. I feel like you do see those two things separated, but what comes with it in law school is almost an attitude as well that is different between the two. So at Duke we have clinical programs, and there are very few professors, there are some, but very few professors that both teach those first year kind of reasoning skills and classes and also do the clinics. And what I've noticed in interacting with both of them is that among the people that go into academics, there's an attitude that their area of academics needs to be addressed by experts in that area. And if you're going to study education, for example, and you don't have the highest level of specialization in that area, then you really shouldn't be talking about it, which leaves people in law school like us who aren't specialists in anything yet completely in the dark, because it's hard to grasp those very high level concepts and go into a law firm and know that those are what we want to dedicate our careers to without some sort of broader scope, where then we have the clinical professors that often have picked an area and are very practically focused, but have that substance under their belts. And I don't understand how, it's just something that I've thought a lot about, but I don't really understand how to take the mindsets that underlie those two different ways of educating people. Because they really are, one's a very high academia and what I do is what I do and nothing else really matters, and the other's very, very practical and much more willing to teach people that just don't know. And how those two communities don't seem to interact with the law schools very easily, much less like coming together for the sake of students that are in that ether in between.
The Carnegie report addresses this, I think, pretty well, because they talk about the three components of a legal education. They say that one of them, the one you're talking, the pedagogic, where you learn the substantive material, is the thing that law school does well. What they say, though, is that the law school is really lacking on the other two, the second one being the skills component, and the third one being the ethical, moral, social side of being a lawyer. The fact that you take ProRes, for example, a lot of the time people will take it in their third year to get it out of the way so they can take the multi-state professional responsibility exam, shows where it's placed. It's not often integrated into the courses. In the program I'm teaching, we have specifically over and over again fact patterns that raise those conflict issues, ethical issues, to make it part of the substantive. And really what law school should be doing, I believe, is integrating those three things so that they're not what you think of as something you have to choose one or the other. They should all be integrated in a way so that it's seamless, which is what Lloyd Bond was saying about our program and about what they were looking for in the Carnegie report.
I think a lot of what you're talking about are different ways to use data in instruction to improve the quality of the
the instruction, improve the quality of the assessment. And as an elementary school teacher, data-driven instruction was our big thing, but our goal was to get everybody to a level of proficiency. And I think that's different from the goal, maybe not the goal, but a fundamental aspect of law schools, which is to provide a signal to the market of differentiation, which is why we persist with these forced curves, even though, you know, you could say, well, everybody who goes to Duke or wherever is qualified and can do the job, but yet we persist with this curving mechanism. And I wonder whether they're fundamentally incompatible, whether we can have more assessment, better data-driven instruction that might be higher quality and yet maintain the curve and whatever value, if any, there is to it.
I guess what I would say is it's become, you're absolutely right, that law schools serve employers, not law students. And, you know, I think y'all should have an issue with that, right? But assuming that is what it is, then what I think is, when I'm talking about looking empirically at what we're doing, I'm looking at, can we teach you better? Can you learn better? And if we still want to curve you, you know, because that's what y'all want, because that's what the employers want, we can still do that, right? But can we do it better? And if we do it better or do it differently, can we narrow the performance gap, right? Are there kind of false variables? For example, Professor Henderson's study showed that that test-taking speed is an independent variable in-class exams, right? Is that a valid variable to be testing in torts or contracts, right? And when you take that variable out and give students take-home exams, you narrow the performance gap. I think we need to do studies, if for no other reason than to have the information. What people do with the information, you know.
I'm a third year, and I actually had the opportunity to work before coming to law school for 2 years. And I almost think, I mean, I know there's some law schools that are moving towards that, you know, model that students should work. I know business schools make students work anywhere from 2 to 5 years. Do you see that as a factor or something to look at kind of pre-law to help with those skills that maybe you can't get in law school?
I haven't really, that's an interesting question. I haven't really thought about how much could be done pre-law school. I guess I would say, from my experience working in law firms with paralegals who are working as paralegals as a way of getting ready for law school, I don't think they get the training and the kind of skills that we're talking about that law schools should provide. They don't interview clients, they don't counsel clients, they don't negotiate on behalf of clients. That's not going to be provided by working in a law firm before you've gone to law school. So I think there are limits on how much that admissions offices, you know, could require before coming to law school that would really make a difference.
I also think that perpetuates the skill versus substance dichotomy, right? You can't do the skills we're talking about if you don't understand the law and how the rules apply. So I think the value of working before you come to law school, it makes law school in some ways a lot easier and less pressure filled, because you're like, okay, I'm a good person and I'm not just an A student who all of a sudden is self-identifying as a B student.
In slightly a different way, which is about an issue that you all touched on a little bit, but that has to do with conflicts within the academy, that how do law schools see it and do they make this a priority? So one trade-off, of course, is if you're spending time doing this, or you're spending time doing your scholarship, but even apart from that, I think it's linked, I think, as Andi said, to issues about what's valued in legal scholarship. So you take my law school, I think the last 10 people that have been hired, maybe only 2 people ever practice as attorneys. So it's hard to, I was one of them actually, but I'm a complete outlier, okay, in that sense. And so, you know, what does that mean? And how do you actually, do you have to have been a lawyer yourself to teach those skills? And I think the response would be they can learn it in their clinical classes, as Julia was saying, and not in their so-called substantive law classes, because we don't have those skills as professors.
In my paper, I address the issue of what the Carnegie report, I probably won't quote this correctly, but to paraphrase it, they talk about the cycle of elitism that is generated from the 5% of people who go to law school to become professors, and the fact that many of the professors teach to that 5%, and that therefore those people then become professors and teach to the next 5%, and so that there's this cycle that isn't broken. I'm not sure if that answers your question, but I think that in order for, well, when you look at the thing, somebody mentioned clinical work versus the traditional. Only recently did most law schools start giving clinical professors tenure track. And some of them still have it as a different kind of track. They're finally giving it some kind of security, but it's a different kind of security. So as long as the schools are telling professors that real tenure comes from being the kind of professor who teaches the traditional courses in the traditional first-year way, then that is what people will continue to strive to do, and that is what they will strive to be, and that is the kind of education that the consumers, you, the law students, will continue to get. If you want it to change, it has to start as a grassroots thing with the law students who are paying 84% of the money, saying that we want a different kind of education. And I know, Professor, that you're not a law student anymore. I didn't mean you, but.
Okay, one more question. Yes.
I just had a quick comment. Actually, thinking about the ways in which students who have worked before law school can really enhance the legal environment. And I very much agree with the sentiment that pre-law school work experience does not substitute for the sort of skills we should be teaching in law school. But I wanted to highlight as well that I think our classrooms really gain another rich layer of diversity when we have students who can better identify as people in the community, as potential clients who can see issues in their larger social context because they have been a part of that and they haven't only been students the entire time through. And actually, as a few years ago as a law student, I remember really being pleased to hear some of my classmates bringing some of those things into the classroom too.
So we're going to have to end it on that note. I think a point that was made here about the impact that the economy is having on the legal profession, which will also have, I think, repercussions for what happens in legal education, is a good time to have this discussion, and I hope that those of you from Duke, I hope that we will continue it, and all law schools should be engaged in this discussion. Thank you.
Okay, so I didn't do the final call to revolution.
No, it was. We thank the panel once again for their remarks and definitely for their insight as professors and as people who want to change the legal profession for the better. This concludes our first annual Duke Forum for Law and Social Change Conference. We would like to send out a special thanks to Dean Levy and the Office of the Dean, the Education Law and Policy Society, Weil Gotshal and Manges, the Duke Bar Association, Career Services. This is basically going to be like the Oscars. I'm thanking everybody. All of our panelists who came today, Professor Coleman, who's definitely helped us not just with this, but also with even bringing the journal to the forefront in the beginning. So, thank you, Professor Coleman. We also would like to thank. I'm sorry. Finally, the subcommittee for the Duke Forum for Law and Social Change, who worked tirelessly week in and week out to put together everything that you guys have seen here. I think that I haven't missed anyone. Our advisors, our precious advisors, Professors Barack Richmond and Neil Vidmar, who've also been helping us as far as our publication, as far as helping to create the vision for our journal, and who will be helping us even further throughout the rest of this year. So we thank you all for coming. We have a reception that is going on, should be going on right now or shortly in the third floor loggia, and we expect that you all will be here once again next year.